Okay, easements. So we are going to talk about easements and how they are created, and some of the case law surrounding easements as well. So firstly, what is an easement? Well, an easement is a proprietary right that is an interest in land. The difference between an easement and, for example, a license is that a license would be not a proprietary right or an improprietary right, meaning it does not survive the sale of land, and because it's not actually attached to the land, it's more attached to the person, whereas an easement is actually attached to the land. There are 4 requirements for an easement to be valid, and this was established and discussed in the case of In re Ellenborough Park, which I believe was 1956. Just to confirm, that was not on my sheet, but anyway, I will look at that one up. That's a really important case. So, in re Ellenborough Park, getting back to that, Ellenborough Park was a typical square in London, and the court held there that the square was that the houses surrounding the square had a valid easement to use the communal square as garden. The court also established 4 requirements that must be met for a valid easement to exist. They are, number 1, there has to be a dominant and a servient tenement. That could also be known as an incorporeal hereditarement. The second requirement is that the servient tenement must accommodate the dominant tenement. The third requirement there is that there must be a diversity of ownership or occupation, so you cannot have an easement against yourself. And the fourth requirement that was developed in re Ellenborough Park was that the easement must be capable of being the subject matter of a grant. So some of the early case law on this dates back to 1879 with Moody versus Steggles. Now, in Moody versus Steggles, that was a case involving a sign, and the defendants in that case argued that the sign was not attached to the land, more so it was attached to the business entity itself, and it was the business entity that was benefiting from this sign, not actually the actual land itself. And in that case, the court held that actually the sign was a valid easement because it would benefit any business that was on that site, and not just the current entity that was there at the time. The next case is Hill versus Tupper. So this case was concerning a man who had a pleasure boating business. He had access to the canal from his property. He argued unsuccessfully before the court that there was, or that he had an easement to operate this pleasure boating business, and that the other properties that had access to the canal were servient tenements to his dominant tenement. It was held in that case that was more of a contractual license, and it was not a valid easement. The next case that we have is Harris versus Flower. This case concerned the ability to get to your land. So essentially, but they developed this rule in Harris and Flower, which was to say that for you to cross someone's land, it only has to be to reach the dominant tenement. So, or vice versa, if you were leaving a dominant tenement, you could cross the servient tenement, and that's what it could be used for, and that does make quite good sense. The most recent case in this set of cases, and these are all to do with the second requirement, which is an easement must accommodate a dominant tenement, is Victory versus Galway Inns Limited. In this case, there was a storehouse which was owned by the defendant. The defendant then purchased land directly adjacent or behind the storehouse and developed a nightclub business there. As a result of this, the storehouse was used to store deliveries for the use of the nightclub, which involved a piece of, the storehouse wouldn't have had a huge volume of traffic going in and out of it prior to that, because it was just a storehouse, but because they now were using this as an add-on, so to speak, to the nightclub, which was directly behind it, the volume of traffic going into that storehouse increased dramatically because of deliveries, etc. So in that case, the court ruled that that was not a valid easement, because it did not benefit the actual dominant tenement in that case. The dominant tenement was the land with the storehouse, not the nightclub, and the benefit being derived from the easement in that case, had it been allowed, would have been the actual nightclub. The nightclub was not located in the storehouse. So the next point I'm going to move on to is the requirement that the right must be capable of forming the subject matter of a grant. So the most topical case in this area is Regency Villas versus Diamond Resorts Limited. This is a recent 2018 United Kingdom Supreme Court case in which there was it was Brook Estate, I believe, let's double check that, Broom Park Estate rather. So in the 80s or prior to the 80s, there was a mansion house there and a smaller house known as Elm House. The mansion house was developed into a leisure complex, gym, and the Elm House was then developed into condominiums, which were used as timeshares and sold as timeshares. There was an outdoor swimming pool and there were also riding stables. Part of the perks of being a timeshare holder was that you could use these facilities for free. In 1981, another company took over and they further developed the mansion house. Over the years ensuing that, the Regency Villas, who had access to the outdoor pool, that outdoor pool was filled in, and the stables were no longer standing. And so by the time that the case was taken, the owners of the other facilities, Diamond Resorts, they initially had denied access to the residents of Regency Villas to a new indoor swimming pool and leisure complex that they had built. And after some negotiations, they did agree to let the residents enjoy the facilities, but at a charge, at a fee. So, having initially signed up for this free perk, the residents were not very happy about having to pay a charge to use these facilities, and so they did take it to the courts. At trial, the judge found that in that case there was a valid easement for the residents of Elm House, now Regency Villas, and that was the dominant tenement over which it had a servitude, or there were servitudes to the Mansion House Diamond Resorts. That judgment was then appealed, and in the Court of Appeal, the court remaining with a lot of what the trial judge said, but changing that judgment in that there was a valid easement, but it did only exist in respect of the facilities that were there in existence at the time when the complex was built. So that would have included the outdoor facilities, the outdoor swimming pool and riding stables, which of course now had been filled in, and they would not have had access to the indoor swimming pool, which was subsequently built. Following this, that was then appealed by the residents of Regency Villas, and the case went to the United Kingdom Supreme Court. In that judgment, the court reversed the amendments and changes made to the judgment of the trial judge and reverted it back to the original judgment of the trial judge, which was to create a full easement there for to be able to use all of these new facilities, all of the facilities, both new and existing. It is worth to note here that in their judgment the court did note that upon the development of the timeshare in the first place, that an officious bystander might wonder how the leisure facilities were to be maintained in the future, should the residents not be paying any type of maintenance fee towards it. The initial reasoning by the developers there was that there would be a country club which would have private paying members, and that should cover the maintenance of the leisure facilities. However, that did not turn out to be sustainable, and so the court did say that an officious bystander at the time may have noted the same, that may be unsustainable. What is important about this judgment is the fact that the courts understood and recognised the right to recreation and the importance of recreation and sports in modern day society, and the benefits that it does have for modern day society. And so they pretty much intertwined that with the land, saying that there was a valid easement because these benefits are important enough to society, that they can constitute a valid easement. The argument of the defendants was that the access to and use of leisure facilities did not satisfy the accommodation requirement of the Edinburgh Park test. Whilst access might add to the timeshare's owners' enjoyment, it was not of practical use or benefit to their land. So again, the judgment basically came down to that unique that factor there where the court held that the ability to for recreation and enjoyment in sports was so intrinsic and so beneficial to society at large, and they found that it actually benefited the land itself, and anyone who was to occupy that land, as opposed to just the people who were living there at the time. Commentary on that is by Rachel Baker, and that was a modern easement for modern times. And this also confirms the ongoing relevance of Ellenborough Park and the principles there, and it also demonstrates the flexibility, malleability of the common law to exist in new and ongoing situations. The court did note in Regency Villas that there were two contradictory authorities on the right of enjoyment as an easement. The first of those was Duncan versus Louch, and in that case the dominant owner had no obligation to repair or maintain the land over which the right-of-way was exercised. So an easement permitting the dominant owner to walk over all parts of the Serbian tenement purely for pleasure can exist in law. However, that was contradicted in Mounsey versus Ismay, and in that case it involved horse racing, and the right to horse racing was not found to be a valid easement, because the court basically said that things of amusement and such were not valid easements. The next subsection of the fourth requirement there, the right must be capable of forming subject matter or grant, is the right to building supports. And underneath building supports we have three different cases here. There is 1885 Latimer versus the Official Cooperative Society, 1965 Phipps versus Pears, and 1993 Tracy versus Dublin Corporation. And so what you have there in Latimer is a right of support to be an easement, and they do not need to be, the structures do not need to be directly beside each other. In Phipps versus Pears, one house was demolished, exposing the other house to the weather, the two walls having originally been built right up next to one another. It was held that the right to shelter for a gable wall from weather could not qualify as an easement, and that essentially there was no easement which guaranteed a building's shelter from the wind and rain. However, this was not followed in Tracy versus Dublin Corporation. That was a Supreme Court judgment in 1993, where the court accepted that there was no right to shelter, as in Phipps, but they did try to, and what they did found in it was quite fact specific in Tracy, in that there was a demolition, and the wall was exposed, but had the wall continued to be exposed, it eventually would have crumbled and would have been unstructurally sound. So in that case, there was a valid easement there, because the removal of this support, it did protect from wind and rain. If the structure could maintain itself with that wall exposed, it may have been a different decision on the court's part, but because that wall was not structurally sound, if exposed to wind and rain, there was a valid easement found there. The next subpoint under this requirement is uncertainty, and it basically states that easements cannot be too uncertain. And this can be seen in the 1926 case of Henry Limited versus McGlade. And this concerned a sandwich board man in a shopping centre, and that was too uncertain to be an easement. Following on from that, the next point we have here is that an easement cannot consist of exclusive possession. So an easement is a benefit to the dominant land. However, that does not mean that you hold exclusive possession of the servient land. In Copeland versus Greenhalgh, there was a wheel repairman who was using part of his neighbour's land to repair vehicles and store vehicles there. And the plaintiff in that case argued that this was a valid easement which was created by prescription, prescription being an easement that is created basically through long-term use. The court held in that case that essentially what the impact of him using this land was exclusive control of that land, and that the correct remedy for his case would be found in the doctrine of adverse possession, and not under an easement, because there is no requirement, and it is not necessary to show adamans possidendi in the case of an easement or exclusive control, and they are not compatible with the easement doctrine. Finally, under the fourth requirement that the right must be capable of forming subject matter of a grant, the ouster principle, which is usually involving parking or storage. The old test up to 2007 was a 2003 case, Batchelor versus Marlowe, and this was to do with an exclusive right to park 6 cars on land weekdays 9:30 to 6 p.m, and that this was an easement by prescription. The court held here that this was not an easement, and the test there was whether the right would leave the servient owner without reasonable usage of that land. However, a new test was developed by the House of Lords in the 2007 case of Moncrief versus Jameson, and that was dealing in Scottish law. The issue there was whether the right of way allowed parking as well as crossing land. Traditionally, a right of way would give you the right to be able to cross a piece of land, but can you be stationary on that land and park something there? It was disputed in this case. And in this case, Lord Scott rejected the test of reasonable usage there, and devised a new test that whether the servient owner has possession and control of the land if the right is used. So essentially what he was saying there was that you could build over the car, under the car, to the side of the car, you could have advertising, and so he did still indeed have that possession and that control, if the car was parked there. And this is also discussed by Xu, XU, in an article. Finally, to the creation of easements, there are 4 ways in which an easement can be created. First is by statute, and the creation of an easement by statute does actually negate the requirement that there has to be a dominant and servient tenement. And the reason for this is, by statute, easements do need to be created in terms of utilities, state utilities, for example, water pipes, power lines, etc. The second method of creation of an easement is an express grant or reservation, and the third method would be an implied grant or reservation. and the fourth method being prescription, again, that is long-term usage. So that is easements. Just a very quick overview running up to the exam. Okay, great.